Good morning, sir. For today, we're presenting our chosen topic entitled Data Privacy Act of 2012. What is Data Privacy Act of 2012? The Data Privacy Act or Republic Act number 10173 is a law that aims to secure all types of information, whether private, personal, or sensitive. It is means to apply to both natural and legal people who are involved in the processing personal data. It's a law for the 21st century addressing 21st century offenses and concerns. It ensures that individuals' privacy is protected while allowing free flow of information to promote innovation and growth. Regulates the collecting, record, organization, storage, updating, or modification, retrieval, consultation, use, integration, blocking, erasures, or destruction of personal data. Ensures that Philippines complies while international data protection standards through the National Privacy Commission. So, what is the purpose of Data Privacy Act 2012? The Philippines approved the Data Privacy Act 2012 in which is comprehensive and demanding privacy law aimed at protecting the basic human right to privacy and communication while maintaining the free exchange of communication to support innovation and progress. Now, here's are some examples of data privacy risks. Number 1. Vulnerabilities in a web applications. Any software hosted in the cloud or on the web should be fully vetted and secure before deploying with an otherwise secure organization. Have data privacy compliance checklist to protect your program before installing something new. Number 2. Insiders and poorly trained employees. Every member of your team should be fully trained and aware of the data privacy basics for which they are responsible. Care given to crafting and enforcing corporate data privacy policy can ensure this is successfully. Number 3. Lacking breach response. An important part of data privacy compliance program is an incident response plan. Make sure you have a clear plan placed, rehearsed, and that your command line is ready to deploy this plan when issues arise. Number 4. Inadequate personal data disposal. Personal data should be kept on only as long relation with the customers or employee and related obligations are in effect. Your organization can incur significant fines under the General Data Protection Regulation. It is the program does not perform this function. Number 5. Personal data sharing. Be sure to inform all users before any personal viable information leaves the database in your organization for which permission has been granted. So, what are the data privacy rights? The law elaborates rights relating to the concept of notice, choice, access, accuracy, and consistency of the data that are recognizable to privacy experts. The Philippines law appears to include a right to forgotten in the form of right to ensure or blocking, which allows data subject to request that her personal data be removed from the data controller's filing system. So, what are the issues and challenges of data privacy? Number 1. Embedding data privacy. Unfortunately, many businesses only have data privacy tagged on their IT, security, or disaster recovery plan, but that's not good enough because data privacy touches on so many parts of your business. Number 2. Proliferating devices. Data privacy becomes harder to handle when you factor things in the internet or bring your own device IT policies and proliferating internet-connected tablets, phones, and watches. Number 3. Increasing maintenance costs. Keeping your system secure and preventing data privacy issues at the enterprise level can expensive, but the cost of the data breach are also significant. You need to bite the bullet and invest properly. Number 4. Access control is difficult. In many industries, data privacy breaches are often caused by poorly managed access with an organization. People and processes matter as much as technology. Humans are the weakest link in the chain of privacy and security. And lastly, getting visible into all data if your organization isn't aware of the location, nature, and sensitivity of your data. So now, Data Privacy Act of 2012 is an act protecting individual personal information in information and communication system in the government and the private sector, creating for this purpose of National Privacy Commission and other purposes.
So let's proceed to the National Privacy Commission. Before we begin, let's answer the question, what is National Privacy Commission? What are the functions? And who manage the National Privacy Commission? The National Privacy Commission is an independent body mandated to administer and implement the Act and to monitor and ensure compliance of the country with international standard set for personal data protection. The National Privacy Commission, or NPC, is in charge of administering and implementing the DPA. It is also tasked to monitor and ensure compliance of the Philippines with international standards for personal data protection. Their mission is a world-class regulatory and enforcement agency upholding the right to privacy data protection while ensuring the free flow of information, committed to excellence, driven by a workforce that is highly competent, future-oriented, and ethical, towards a competitive knowledge base and innovative nation. They are also have three services to deliver continuously. First is to be authority on data privacy and protection, providing knowledge, know-how, and relevant technology. The second is establish a regulatory environment that ensure accountability in the processing of personal data and promotes global standards for privacy and protection. The last is build a culture of privacy through people empowerment that enables and uphold the right to privacy and support free flow of information. Who manages the National Privacy Commission? The Commission shall be attached to the Department of Information and Communication Technology, or DICT, and shall be headed by a Privacy Commissioner who also acts as a chairman of the Commission. The Privacy Commissioner shall be assisted by two Deputy Privacy Commissioner, one to be responsible for data processing system, and one to be responsible for policies and planning. The Privacy Commissioner and the two Deputy Privacy Commissioners shall be appointed by the President of the Philippines for a term of 3 years and may be reappointed for another term of 3 years. Vacancies in the Commission shall be filled in the same manner in which the original appointed was made. The Privacy Commissioner, the Deputy Commissioner, or any person acting on their behalf of under their direction shall not be civilly liable for acts done in good faith in the performance of their duties. However, he or she shall be liable for willful or negligent acts done by him or her which are contrary to law, morals, public policy, and good customs, even if she or he acted under orders or instruction of superiors, provided that in a case or lawsuit is filed against such official on the subject of the performance of his or her duties where such performance is lawful. He or she shall be reimbursed by the Commission for reasonable cost of litigation. The Privacy Commissioner must be at least 35 years of age and good moral character, unquestionable integrity, and known probity, and recognized expert in the field of information technology and data privacy. The Data Privacy Commissioner shall enjoy the benefits, privilege, and emolument equivalent to the rank of secretary. The Deputy Privacy Commissioner must be recognized expert in the field of information and technology and data privacy. They shall enjoy the benefits, privilege, and emolument equivalent to the rank of Undersecretary.
Processing of personal information. General data privacy principles. The processing of personal information shall be allowed subject to compliance with the requirements of this Act and other law allowing the disclosure of information to the public and adherence to the principles of transparency, legitimately purpose, and proportionality. General principles: transparency, legitimate purposes, proportionality. Personal information must be when collected for specific and legitimate purposes. 2. Process fairly and lawfully. 3. Accurate, relevant, and keep up to date. Inaccurate or incomplete data must be recertified, supplement, destroyed, their further processing restricted. 4. Adequate and excessive. 6. Retained only for as long as necessary for the fulfillment of purposes for which the data were obtained for the establishment, exercise, defense, legal claims for the legitimate business purpose or as provided by law. And 7. Keep in the form which permit identification of data subject for longer than is necessary for the purposes the data were collected and processed, provided that personal information collected to other purposes by lie, process, historical, statistic, or scientific purposes, and in case laid down in the law many longer period, provided further that adequate safeguards are guaranteed by authorized their processing. Criteria of lawful processing of personal information. The processing of personal information shall be permitted only if not otherwise prohibited by law, and when at least one of the following conditions exists. 1. The data subject has given his or her consent. Note: consent of the data subject refers to any freely given, specific, informed identification of will whereby the data subject agreed to the collection and processing of personal information about and or relating to him or her consent shall be evidenced by written, electronic, or recorded means. It may also be given behalf of the data subject by an agent specifically authorized by the data subject to do so. Pangalawa, the processing of personal information is necessary and is related to the fulfillment of a contract with the data subject or in order to take steps at the request of the data subject prior entering into contract. Pangatlo, the processing is the necessary for compliance with the legal obligation to which personal information controller is subject. Processing of personal information, privileged information referred to any and all form of data which under the rules of court and other pertinent law constitute privileged communication. Sensitive information refer to personal information about individual about individual race, ethnic origin, martial status, age, color, or to any philosophical or political affiliation. Pangalawa, about individual health, education, genetics, sexuality, life of person, or to any proceeding for any offense committed or allied to have been committed by such a person, the disposal such as proceeding or the sentence of any court in such proceedings. Pangatlo, issued by government agencies peculiar to the individual, which include but not limited to social security numbers, previous crime rent, health record, license, or it denials, suspension, or revocation, and tax return. And pang-apat, specifically the established by the executive order or an act Congress to keep classified. Subcontract of personal information. A personal information controlled by subcontract the processing of personal information, provided that the person information controller shall be responsible for ensuring that proper safeguards are placed to ensure the confidentiality of the person information process, prevent its use for unauthorized purposes, and general comply with the requirements this act and other law for the processing personal information. The personal information processor shall comply with all the requirements of the act, the other applicable law. Extension of privileged communication. Extension information controller may be invoked the principles of privileged communication over privileged information that they lawfully control process subject existing laws and regulation. Any evidence gathered on privileged information is inadmissible.
Rights of the data subject. So, um, the consumer or the data subject is a principal source of information of a business and non-business entities in formulation of their strategies and operations. Data subject stands at heart and center of data protection laws here in the Philippines. Republic Act 10173 or the Data Privacy Act of 2012 protects data subjects while ensuring the free flow of information, thus protecting data subject from attacks, abuses, and negligence should be the highest priority. Government agencies and private institutions must commit to treating data with the best care, consideration, respect, through strategizing and pouring resources into ensuring the security of their customers and stakeholders' privacy data or data privacy. Any information supplied or declaration made to the subject on this matter shall not be amended without prior notification of data subject, provided that the notification under subsection B shall not apply should the personal information be needed pursuant to a subpoena or when the collection and processing are obvious purposes, including when it is necessary for the performance of or in relation to a contract or service, or when necessary or desirable in the context of an employer or employee relationship between the collector and the data subject, or when the information is being collected and processed as a result of legal publication. Transmissibility of rights of the data subject. The lawful heirs and assign of the data subject may invoke the rights of the data subject for which or she is an heir or assignee at any time after the death of the data subject, or when the data subject is incapacitated or incapable of exercising the rights as enumerated in the immediately preceding section. Right to data portability. Portability. The data subject shall have the right for the person how information is processed by electronic means and in a structured and commonly used format to obtain from the personal information control a copy of data undergoing processing in a electronic structured format which is commonly used and allows for further use by the data subject. The Commission may specify the electronic format referred as above, as well as the technical standards, modalities, and procedures for their uh, transfer. Non-applicability. The immediately preceding sections are not applicable if the process personal information are used only for the needs in scientific and statistical research and on the basis of such no activities are carried out and no decisions are taken regarding the data subject provided that the personal information shall be held strict confidentiality and shall be used only for a declared purpose. Likewise, the immediately preceding sections are not applicable to to, to processing of personal information gathered for the purpose of investigations and in relations to any criminal, administrative, or tax liabilities of a data subject. So in the Manila Bulletin, we have the 8 rights of the data subject. First is to right to be informed. So the data subject should be informed if any actions take to the data subject's information. So it has to right to access and right to the object and right to erasure or blocking and right to damages and right to file a compliant and right to rectify and right to data portability.
Security and sensitive personal information in government. First, we have the security of personal information. The personal information controller must implement reasonable and appropriate organizational, physical, and technical measures intended for the protection of personal information against any accidental or unlawful destruction, alteration, and disclosure, as well as against any other unlawful processing. Next, we have the responsibility of heads of agencies. All sensitive personal information maintained by the government, its agencies, and instrumentalities shall be secured as far as practicable with the use of the most appropriate standard recognized by the information and communication technology industry and as recommended by the Commission. The head of each government agency or instrumentality shall be responsible for complying with the security requirements mentioned herein, while the Commission shall monitor the compliance and may recommend the necessary action in order to satisfy the minimum standards. And next, we have the requirements relating to access by agency personnel to sensitive personal information on-site and online access, except as may be allowed through guidelines to be used by the Commission. No employee of the government shall have access to sensitive personal information on government property or through online facilities unless the employee has received a security clearance from the head of the SARS agency. And Next, we have the applicability to government contractors. In entering into any contract that may involve accessing or requiring sensitive personal information from 1,000 or more individuals, an agency shall require a contractor and its employees to register their personal information processing system with the Commission in accordance with this Act and to comply with the other provision of this Act, including the immediately preceding section, in the same manner as agency and government employees comply with the such requirements. And next, we have the unauthorized processing of personal information and sensitive personal information. The unauthorized processing of personal information shall be penalized by the imprisonment ranging from 1 year to 3 years and the fine of not less than 500,000 pesos, but not more than 2 million pesos, shall be imposed of person who process personal information without the consent of the data subject or without being unauthorized under this act or any existing law. And lastly, we have the accessing personal information and sensitive personal information due to negligence. Accessing personal information due to negligence shall be penalized by the imprisonment ranging from 1 year to 3 years and a fine of not less than 500,000 pesos, but not more than 2 million pesos, shall be imposed on person who due to negligence provided access to personal information without being unauthorized under this act or any existing law. And that's it. Thank you for your listening and bye.